Hey everybody, great to see you. Good to see you this morning. How are we all doing? I'm here to talk about general employment tribunal problems and also if you want to talk about the new tipping bill. Good morning, Rebecca. Good morning, Sue. Yeah, great to see you all. So yeah, as you can see, I've been doing a few videos on the new tipping legislation. So if people want to talk about that, I can answer some questions. We'll see if I can answer them all. I can look them up. And also, if you're just having a problem at work, if you have a employment tribunal situation going on, hi, Chef, then I'm happy to answer that as well. For those who don't know me, my name is Danae, and I am the creator of Vala, which is a platform that allows people to manage their own legal problems at work when they can't afford to kind of go the full fat law firm kind of route. Oh my goodness, Jamie, just wanted to say I've had my final hearing and have the verdict next Thursday. Okay, this is on TikTok. I'm live on TikTok and YouTube. Can we all just give Jamie love hearts? Huge well done for getting through that final hearing. How was it? How was it, Jamie? Oh my goodness, I got my settlement without prejudice, 6 figures more because I logged everything. Watermelon. Well done. Oh my God, more love hearts. And we've got love hearts going for you over on YouTube as well, Jamie, and Watermelon. Oh my God, that's incredible. Huge well done to both of you. That is so well done. I love hearing about your success stories. I love hearing about success. And I love hearing as well when people say, you know what, I had a look at it. I understood my options. I decided not to take it forward because I decided to prioritize some other part of my life, my mental health, my health, etc. You know, we are not in the business of getting people to go to tribunal. We are in the business of helping people make an informed decision about what to do. And that is why I started Vala, was because people couldn't make an informed decision. People were just like, I and others were, you know, we felt like we had no other option other than just quit and go on and try and find something else. And that is the thing. Like it's you should be able to make a choice. I want to settle. I want to go to tribunal. I want to move on with my life, but I know that I have stood up for myself to this degree. I know that I have looked into my options and made a choice here. That is the thing that's important, and that's what I really want to celebrate with all of you. Oh, I didn't go to tribunal. They were too scared and they approached me directly. Oh my God, well done, Watermelon. Super well done. Randall is asking about the tipping law over on YouTube. So I will answer that in just a second. I see I've got a few questions here first. So let me just see. Rebecca is asking, can you explain protected windows for discrimination? Do you mean when it comes to pregnancy and maternity, Rebecca? Because I know that there is a window of time where pregnancy and maternity discrimination kicks in. Is that the one that you're asking about? Oh, Chelsea has settled as well. Huge well done, Chelsea. Oh, can I ask a favor? So for all of you amazing people who are getting your outcomes, would you mind going to Trustpilot and writing a review if we had any hand in helping? Because I would just love for other people to know that, you know, it might be that you didn't even buy a product from us. It might be that you just use the platform or you watch the videos here. But if you wouldn't mind going to the Vala page on Trustpilot and just writing us a little review, that would be amazing, because it makes a difference for other people. Okay, so let me see if, oh goodness, okay, hold on. My setup is here, but I've just not set it up correctly. So let me just do this. 1 second. Whilst I'm doing this, I'm going to answer Randall's question about the tipping law, and then I will come back to the other questions on TikTok. Thank you so much, Jamie. So Randall, there is a new law that's coming into effect on the 1st of October. If you go to the videos on YouTube or TikTok, I have covered off what it does. But the key thing is that in the past, up until the 1st of October, so now, presently, if someone tips with a card or in other ways where the employer collects the money, the employer is not obligated to pass that money on to the employee, to the server, to the back of house, to anybody. They could just legally keep it. But if you were to hand someone cash, that is legally their money. Whereas now, with this new tipping law coming into effect, employers who collect tips on behalf of their employees must give that money to the employees, and it must distribute them fairly. Now, fairly might just mean that the server who served you got the tip, or it might be that they, you know, set up some kind of trunk system so that there is a distribution. But they have to set up a system. They have to write it down. they have to hold to it, and they have to show the receipts of who they have distributed to the money to and when, and they also can't withhold tips for more than a month now. They can't take the transaction charges off the tips as well. So these are all changes that are coming into effect on the 1st of October. And I've got a few more videos about it if you want details. Randall, does that answer your question? Yeah, it's really good, Luke. It's really good. It's closing that loophole because, you know, we used to all tip in cash. Now we tip by card. And a lot of people didn't recognize, myself included, that the employer had zero obligation to pass along those tips. I mean, often many of them did, but they had zero obligation legally to do that. Okay, so let's see if I can get some questions in here on TikTok. So let's see. I think I've missed a few when I loaded up the browser. One second. Okay, so Rebecca's coming back to me on the protected windows if she's talking about pregnancy and maternity. I was refused reasonable adjustments for my return to work after long-term sick due to disability. Okay, so Sean, maybe? I hope I'm getting your name right. I'm really sorry to hear that. So an employer, they have to be reasonable adjustments. So the employer has the right to refuse, but they have to be reasonable. Like the employer has to be reasonable as well. And they have to try. So if you, for example, have asked for reasonable adjustments and your employer is just like, no, shut it down, absolutely not even engaging with this, then that is very likely not going to pass the sniff test when it comes to the tribunal. They have to engage with you and see if they can make accommodations. And, you know, that can't just be like a decision, shut it down, computer says no situation. So it'd be good to see kind of where you are with that. Alex, I only work 10 hours a day, 5 days a week, but holidays are only paid 8 hours. Okay, is this allowed? So are you, Alex, so you're saying you work 10 hours a day, but they're only letting you accrue holidays for the 8 hours that you work? Is that right? That doesn't seem right. Is that what you mean? And what is your contract? Like, are you contracted to work 10, 8, none? Like, how does that work? Hi, TikTok Watch. Good to see you. Yeah, my name is Danae. Vala is my company, but I don't want. I want the profile to be the company because it's not about me. Me as the company. I'm just the person who's chatting to all of you. But behind me is a whole team of people. So when you email us, for example, at hello@vala.uk, I have a team of people who are looking after that inbox. When you DM me, there's a much smaller team. So don't DM me, email me, and the team will be able to respond back to you. And and a whole product and everything else. Okay. I have had an appeal, and my evidence is an HMRC tax submission for my hearing, predetermined. Is this okay? I have an appeal, and my evidence. So Tom, do you mean a grievance appeal or a disciplinary appeal? Did I miss an earlier message? If you did explain that, I'm so sorry. I'm just catching up. Okay, so it's me said, hi, can I ask occupational health to redeploy my line managers, to redeploy me? My line managers won't accept my request to work from home. Okay, so it's me. Is this in relation to a discrimination claim or a discrimination situation? Sorry. Is this in relation to a disability or something else? Okay, so so Rebecca had asked about windows of discrimination. Now, this is specific to pregnancy and maternity. Now, Rebecca is asking about miscarriage. So first of all, Rebecca, I'm so sorry that you had to deal with that. So in the situation of a miscarriage, I actually have a video about this on my profile, and I'm going to try and remember the details, but please, Rebecca, do go and watch that video. It's very short, but it does cover the very specifics. So the way that the legislation is worded is after a pregnancy has finished. So in the case of a miscarriage, after a miscarriage, there is a time window, and I really can't remember how long the window is, but I will see if I can figure it out on the live. There is a time window after the pregnancy has finished where pregnancy and maternity discrimination still applies for that person. So people who have had a miscarriage will still have protections after the miscarriage has happened for a certain amount of time. I believe it's at least a month. And so that means that if you had a miscarriage and you are being treated in a what's the word? If you are being treated differently, if you are oh my goodness, my brain this morning. If you are being treated worse than other people, basically, as a result of that miscarriage, then yes, especially within that kind of first few weeks after the miscarriage, that window is still open for that to count as discrimination. Rebecca, let me know if watch the other video, but let me know if that helps tease out what you were looking for there. Randall over on YouTube, I reported to HR about how I was discriminated against. I got put into a meeting where I was harassed for reacting to the discrimination. Is that victimization? So victimization is one of the things that I talk about a lot because there is a kind of common word for victimization, and then there's a very specific legal term. In your case, Randall, this sounds like it's moving towards the very specific legal definition. So victimization in the Equality Act is when you speak up about discrimination, naming the protected characteristic. So for example, I think I'm being mistreated because I am Black, or I think women in this company are being treated differently. You don't even have to be a woman to speak up about discrimination and have the protection. If you are then treated with a detriment, if you suffer a detriment as a result of speaking up, and you can link them, usually it's timing, everything was fine, I spoke up, suddenly I was being treated badly, or in your case, you were being harassed as a result of that, then yes, that could qualify as victimization. So I would suggest, Randall, if you are in the heat of this, if you want someone to take a very specific look, I would recommend that you speak to one of our coaches for a merits assessment. If you go to the link on my profile, or if you just go to the VALA website, if you scroll down on the homepage, you will see the merits assessment service. That's where you can upload kind of the documents about what's going on. You can ask questions. One of our coaches will have a look at your case with you, answer your questions on a call, and then give you a report saying, here's where I think you might have some legal claims, here's where I don't think you do, and here's how much it could be worth in a ballpark range if you were to kind of take it to tribunal and win. Or if you want to settle, here's how much kind of roughly to think about. So I hope that answers your question, Randall. If you, Randall, want to know more about that before you go forward with it, just email us, hello@vala.uk. Okay, let's go back to questions. Okay, so Rebecca said I had the miscarriage in August and they pulled me into the capability meeting in the April. Okay, so I doubt that that window is open for pregnancy and maternity between August and April. You might want to look at, so the other thing, often pregnancy and maternity discrimination, that protected characteristic intersects with sex. So if you think that, so for example, sex discrimination also can be triggered around caretaking duties, because the court recognizes that women disproportionately are asked to take on caretaking duties and things like that. So it might be worth looking, oh, thank you. It might be worth looking at sex discrimination as well. Again, in your case, Rebecca, if this is an ongoing situation, it sounds horrible, and you do want to get somebody's specific advice, check out the merits assessment. The other thing, what would I do? And what else would I suggest that you to do? I would look, I think I did a video recently about sex discrimination. Look at sex discrimination, have a look. And when I say it in these lives, go and look at something, there's a few things that I mean specifically. The first one is go to the gov.uk employment tribunal decisions page on gov.uk, where you can read cases. So you can you can search on the page sex discrimination and look at cases and read how the judges have actually described what counts as sex discrimination and what doesn't. So in your particular case, Rebecca, you could search miscarriage, sex discrimination, and things like that. The other thing that when I say go and look into it, if you go onto our page, vala.uk, we have a ton of resources. We've actually taken a lot of real cases and done the reading for you and kind of broken them down in the real examples section of our page. So hopefully that will give you some pointers as well. Okay, right, let's see. I've got some more questions. Sorry, I'm not getting to everyone. I'm just kind of plowing through. Luke says, my current company currently doesn't pay an average of regular overtime bonus payments on my holiday pay. So Luke, was this in regards to the 8 hours, 10 hours thing? No, that was Alex. Okay, so my company currently don't pay an average of regular overtime bonus payments on my holiday pay. What is a reasonable amount of time for them to start this, and should I get back pay for this? Yeah, I mean, there is your employer. If you work the hours, you should be accruing holiday for those hours, is the short version of that. The specifics of accrual across overtime, I don't know. And I think that's the question that you're asking. I actually would phone ACAS for this one. They are very good around holiday time, sick pay, that kind of stuff. So I would give them a call and double check how that time should be accruing for you. And yes, if your employer should have been paying it, then they should have been paying it, and they should back pay you for that. Okay, so It's Me had asked about occupational health, redeployment. They won't accept my request to work from home. So this sounds very much like a reasonable adjustment request for a disability. It's Me. So I'm assuming if you don't know about there are 6 types of discrimination. 3 of them, so all 6 of them actually, it's the only protected characteristic that all 6 apply to: disability. And failure to make reasonable adjustments and discrimination arising from a disability are specific only to disabled people. And I would encourage you to look at both of those to see if the situation that has happened to you applies there. Discrimination arising from a disability is one of the lesser known but most powerful potential claims at tribunal for disabled people. And I have some videos that explains that, and highly recommend you look at our website that talks about it as well. Okay, so Helen says, I raised a grievance that was not upheld, which I have appealed, awaiting for the outcome. Can I still go forward to tribunal? Absolutely. So this is so important. Look into my eyes, everyone. If you have a dispute with your employer, you only have 3 months minus 1 day from the incident occurring, not the time that you raise the grievance, the incident occurring, the last incident occurring, to start ACAS early conciliation. Do not wait for a grievance process to finish to start ACAS early conciliation. You can run both at the same time, and often people do. So if you are hitting that 3-month deadline, 3 months minus 1 day, and a grievance appeal is still outstanding, all that kind of stuff, start ACAS early conciliation. It's just filling in a form on the ACAS website. The employer gets contacted. That pauses the clock. That retains your legal privilege to go to tribunal. It retains that leverage that you have, because employers, if you don't have that leverage, they might not take you as seriously. So absolutely, yes, you can still go to ACAS early conciliation, which is the next step before you can make a tribunal claim. That is a required step that almost all claims, it's only in the case of I think the protective award that you don't have to do it. So yes, definitely, Helen, do both. Emily says, currently going through employment tribunal. Can I talk about it, or should I not be mentioning it? You absolutely can talk about it, Emily. There is no reason why you can't talk about it. In fact, justice is transparent. Employment tribunal decisions are published on the internet. You absolutely can talk about it. You can also, you can talk about it within the company if you want to, especially if you're trying to get someone to act as a witness for you. So yes, you absolutely can talk about it. Okay. Right. Fancy coming helping me. I'm court. I'll treat you if I win. I have had 2 preliminary hearings already. A tempting proposal, Witten. So if you do, we can help you, and we don't charge the same rate as law firms because we don't represent you. We help you represent yourself. So if you do want to talk to one of my coaches who really can help, they are all experienced litigators. They all know the tribunal inside out. Then go to our website, vala.uk, and look on the coaching tab, and you can book time with our coaches. Johnny, I don't know. So my workplace was secretly listening to my private conversations at home. Is this legal? No consent. So this is something that I keep meaning to look into, Johnny. My instinct is that it's probably not, but I do not know. I'm so sorry. But I will see if I can find out and record that in a future video. ACAS might know, so I would maybe give them a phone. My workplace are telling us that they want people back in the office. Can they force us in? We did a guide article about this, so if you could go to our website, you can check that out. The short version is it depends on your contract. Where is the place of work listed on your contract? And what does it say in your contract about the place of work? If it says that you're remote, then no, they can't. Without changing your contract. If it says that it is in a particular location, then it's going to be harder for you. You can also remember the right to have a flexible working request. You can make a flexible working request and your employer has to take that seriously. And if you have a disability, one of the most common reasonable adjustments is requesting to work from home. So you have some options depending on what your contract says, what your personal circumstances are. Ree says, I raised concerns about a manager. He retaliated by putting me on a PIP, a performance improvement plan. I filed a grievance. What legal standpoint do I have? Ree, great question. It depends on what the concerns were about. If you raise concerns about anything to do with a protected characteristic in relation to your manager, then you would likely have victimization protections. And we talked about victimization earlier with Randall. And if you look on the VALA website about victimization, you will see some details there. If you were raising concerns about something related to whistleblowing, for example, if you think that they were committing fraud, there was a public interest health issue, things like that, then there could be whistleblowing protections in place for you. And there's a few other things as well. So it really depends on what the concerns were about. Queen of Vela, shining bright. Oh, you're very kind. Just ask Yaz. Can a grievance that has gone through the process and still taking longer than 3 months still be taken to tribunal? Helen, the short answer is yes, but it's just harder. We did a whole webinar, in fact, about how to ask the tribunal to approve out-of-time claims, which is outside of the 3 months. In your case, I would absolutely start ACAS early conciliation like today if you want to retain that right. Often, if you hadn't taken legal advice and you didn't know about the window and you didn't have access to a union or any other types of legal advice, you can make the argument to the tribunal that you were waiting for the grievance process to finish in good faith and you didn't know any differently. So yeah, you still, if you want to preserve the ability to then make that argument, start ACAS early conciliation immediately. Okay, so Rebecca says, I had ongoing health issues related to the pregnancy outside of the protected window. Now, if those ongoing related health issues had a significant impact on your day-to-day life and lasted for more than 12 months, then that could be considered a disability, in which case you would fall under that protected characteristic, Rebecca. So it's worth looking into that as well. Okay, Willow. Oh, God. Hi, Allegro. Willow, I was dismissed after telling my employer I had ADHD. Now they're saying it's performance issues. Okay, well, that's like, on the face of what you just said there, that's totes illegal. You can't just dismiss someone because they told you they have ADHD. First of all, you definitely can't just dismiss someone because they told you you have ADHD. If you had requested accommodations, they need to engage with you on those requests. Otherwise, that constitutes a failure to make reasonable adjustments. If they just outright sacked you after you telling them that they had ADHD, you had ADHD, and you think it's because of that, then that could be direct discrimination. If everything was kind of going fine and they were getting good feedback, and then suddenly you told them and everything changed, that would be one of the ways that you could prove something like that. All of their reasons for dismissal were faults of their own, not telling me the rules. Yeah. Willow, I would, if you want to talk to somebody about this, that is exactly what we designed that merits assessment for. So go to the link in my profile or go to the homepage of VALA, scroll down, and you'll see that merits assessment. And we can go through the specifics with you about a dismissal that was illegal because of a disability. And also, if you worked at the company for over 2 years and they didn't follow a fair process, there also could be an unfair dismissal claim there. Right. Hi, Big Mama. Good to see you. My ex-employer has still not paid my unused holidays, but I have the P45 already. Oh, my goodness. I'm so sorry that you have to deal with that still. Hey, Guara, good to see you. Just want to say thanks. Thank you so much, Enigma. That is very kind. I it was literally the day after telling them that I had ADHD. Actually asked if I could talk about reasonable adjustments. They denied. I was there for 1 month minus a day. They tried to use probation period as an excuse. Okay, so your disability protections are a day one right. In fact, they don't even start at day one. They actually start during the interview process. So the fact that they sacked you the day after you asked for a reasonable adjustment without engaging with the reasonable adjustment process, they are going to really, really, really struggle to justify that to a tribunal. Like, absolutely. I definitely think if you do want to take this forward, start ACAS early conciliation. And when I say start ACAS early conciliation, literally that is going to tell.acas.org.uk and filling in a form. And then that ACAS gets in touch with the employer and says they think that somebody thinks that this is the employee would like to negotiate with you because they think that this was illegal. And then whether or not they negotiate, they can decide whether or not to. And then if they choose not to, then you have basically got the clear from ACAS to go to a tribunal claim. Willow, in your case, like, can I strike out their counterclaim if it's categorically false and disproved? So the way this will probably work is, let's say you go into ACAS early conciliation. You'll test then whether or not they're interested in just like settling to try and make this go away. So say you're saying, I want this many months salary because it's taking me that long to find a new job, or whatever it is. So you might find that they engage at that point. If they don't, then you could then go on to file a tribunal claim, in which case you would get this response back called an ET3. Generally, it is like an all-out denial of everything and saying that you're crazy and all kinds of other stuff. It's a really tough document to read, but it's really up to the judge. And you would get your day. Usually, an employer, typically at a certain point, looking at the legal bills that they have to pay, starts to become more interested in the idea of settling, but not always. Employers are people, right? They're just like us. So yeah, I can't, they didn't want to engage. Oh, okay. Oh, Willow, you've already gone through these processes. They didn't want to engage in early conciliation. They're outright lying in their ET3, just as I predicted. Oh my goodness, Willow, I'm so sorry. Yes. So Willow, in your case, if you have like damning evidence, if that day after kind of stuff sounds pretty damning, you could, at a minimum, you could ask for a deposit order, which is going to the tribunal and saying, hey, I think they have a very, what is it? There's two phrases between strikeout and deposit order. Strikeout, if you're asking for a strikeout, it's no reasonable prospect of success. I believe that there is no reasonable prospect of success, so I would like the tribunal to strike this out. If you want to kind of like go in on the softer side, you can say it's little reasonable prospect of success. And so in order for the case to keep going, I want the respondent to pay £1,000 deposit to the tribunal, basically asking them to put up or shut up because I think that their defense is terrible. So that might be what you want to look at. Oh, thank you, Jack. That's very kind. Z over on YouTube says, I have a tribunal case coming up next year, and the most senior manager has now left the business. Will this be in my favor or not? Even if they've left the business, they will still be able to be called as a witness. And the tribunal can actually compel people to come as witnesses. So it depends. I would say it's a neutral. I would say it's a neutral Z. Yeah, I hope that helps. Emily says, our situation is just similar, been through the PH, just waiting for the second part of it. Okay, so if the two of you aren't yet using Vala as a platform, the free parts of it, just to look after your case and things like that, please do go and do that. If you find it useful, please do. And if you are looking for some support, there's two things I would recommend. One is sign up for our newsletter on any page of our website, basically, and you'll get invited to our employment tribunal support groups, which are free, and we'll put you in touch with other people. And then also, if you want to talk to any of our coaches, as some of those dates come up and you might want to get help preparing and things like that, that's what the coaching page on the website's for. How does it work with multiple respondents and a costs order? Would they all pay the fee? It's a good question, Maggie, and I don't actually know. That's a very good question. Um, I suspect that the cost would be the cost. So let's say that you won a cost order for £5,000. I think the judge would then the you wouldn't get £5,000 twice if you had two respondents, if that makes sense. But I don't know how that gets divvied out between multiple respondents. It's a great question. I paid for Vala for advice prior to my PH and was great advice that their solicitor did not challenge anything. I was quite surprised how ready I was. Oh, Zed, this is an amazing thing. Oh my goodness. I'm so pleased to hear that. That must have felt so good at the time. I'm going to take a little screenshot for that for the team. Zed, would you mind doing a review for us on Trustpilot? Like if you haven't already, maybe that is amazing. That is so good to hear. That's all we want is we want people to be able to come into these situations like a scary PH and be able to do something about it. Like, not knowing kind of what they're doing, not knowing what you're doing is so scary. So I'm pleased to hear that. Let's see. I've got judicial mediation in March. What happens in this? So Sarah, we don't have a ton of experience on judicial mediation. Actually, my coaches do. I just don't. I don't have a ton of experience on judicial mediation. But typically, so the whole point of judicial mediation is to try to kind of shortcut the thing. So the judge is going to do a lot of reading rather than days of hearing. That's what they're trying to kind of see is like, can we avoid having to go through like 5 days of hearings, for example, for the court's time, for your time, for the employer's time. And so judicial mediation is all down to the written argument. And so if you want to prep for judicial mediation, get your argument as tight as possible written down as to what happened, why you think it was illegal, what evidence you have, etc. That's so important. And so and remember, you don't have to, it's not binding. You can just go through it and see what happens. The judge will basically read through everything and then give a feel for what they think, how strong they think the prospects are of the situation. So that written argument is the most important thing going into judicial mediation. If you want help with that, you can use one of our coaches and we can help you kind of understand how to structure that. Okay, can I just get paid without having to deal with work? So Mayday, I don't know if you're just like expressing the general kind of like vibe or if you're trying to make a point. Either way, it's not what this live is about. Hi, my employer has not unpaid me, then blocked me when I sent a formal grievance. What do I do? I don't know what unpaid means, Ray. If you mean that they haven't paid you for something, but if they owe you money and they are ignoring you, then ACAS underpaid. Oh, right. Okay, yeah. So ACAS early conciliation is your next step, and if you look at the potential tribunal claim for this would be either unpaid wages or unlawful deduction of wages. I've got an employment tribunal date on 23rd September. Will they settle before? Roxy, it really depends on the employer, right? Like some employers are rational actors, some are not rational actors. Like it's so hard to predict. But I will say that the temperature increases for the tribunal or for the employer as tribunal gets closer because they're realizing how much they have to pay the lawyer to represent them. And so it's one of the cases where we do see employers engaging. So yeah, definitely possible, but I can't guarantee it under any circumstances. Mayday says, I'm just generally annoyed with working. I mean, I get it, Mayday. Also, my union said yes to a mediocre contract. Oh, I'm sorry to hear that. Yeah, no, I get it. My PH is coming up. Can I request to add more witnesses? Yes. So a preliminary hearing that is a case management preliminary hearing is designed for figuring out how the final hearing is going to go in terms of process. So if you want witnesses to call witnesses, then that is the time to ask. If you want like an accommodation, can it please be online because I can't attend in person or anything like that is what the PH is for. So yes, Randall, that is the perfect time to go for more witnesses. Zed, my case has media attention and was contacted by a few of them, but at the moment I refuse to comment until after my court case. Is this the right thing to do, as it was already featured on BBC and ITV? Zed, I think that's a good strategy. Also, we offer for people who have kind of won their cases or in those like at that remedy hearing stage, we can help you with the media aspect of it because it's really scary, right? I think it's right to ignore the media until after you actually get the case heard. I don't think that's going to do you any favors. But if after the case has been heard, you want to talk to the media, drop us an email at hello@vala.uk and we can put you in touch with somebody who can support you with that for free. It's just because it's in our best interest too, because we helped you. And so in exchange, we just ask that you mention that Vala helped you, but it means that you get some media training. Okay. Yeah, so Mayday saying I'd panic over the risk of a defamation lawsuit. Yeah, that's why I would wait. I've got judicial mediation and 3 respondents. One wants to settle and the others 2. Will that go to ET? Again, very interesting question about multi-respondent cases, and I don't know the answer. So really good questions. So actually, you probably could settle. This is just off the top of my head, Miss Diva, so let's just work through this. Let's say you've got A, B, and C as your respondents. A wants to get out. They want to settle. You could withdraw your claim against A, but maintain your claims against B and C in exchange for a settlement. I think that's how that would work. If you're getting settlement negotiations, assuming it's not through ACAS, you would need to get a lawyer to represent you anyway, because a settlement isn't legal unless you are represented by a lawyer or it goes through ACAS. So I would either ask the lawyer who's going to support you or ACAS how that works. Or again, you can use Vala Coaching if you go to our website. They even attended my workplace to speak to me. Honestly, sometimes journalists can be so aggressive. Wow, that's a lot, Zed. I'm so sorry to hear that. I think you're in the right to not speak to them. Syed says, what happens after the preliminary hearing? Good question. So the preliminary hearing is like a business meeting, right? And it helps figure out when is the final hearing going to be? Are you going to call any witnesses? How many days is it going to take? Who's got time on these days? Who's on holiday? That kind of stuff. What are the list of issues? What are the key legal issues that need to be decided? That's the most important part of the PH. After that, you're going to get a series of case management orders. Now that is basically a set of deadlines from the tribunal to do the rest of the paperwork before the final hearing. So the case management orders will say, by this date, you're going to go through the disclosure process with the respondent. That means you're going to exchange a list of documents, and then you're going to exchange those documents. You're going to prepare the bundle. You need to prepare a schedule of loss, your witness statements, all that kind of stuff. They'll give you the deadlines for all of those. And so then that's what you start working to. That is, again, where our coaches can help you if you don't have representation to get all those documents ready, to do the disclosure process, etc. Let's see. Is it worth requesting a paper hearing so that I don't need to meet my employer at the hearing? Pritesh, I think it really depends on how strong your written argument is. I would suggest that you ask for a remote hearing if you think that being in the same room as the respondent is going to cause, so much distress, rather than lose the ability to get to say in your own words what has happened. But yeah. 5 years of disability discrimination, tribunal in May for 3 weeks, a 3-week case. My goodness, I have a Vala coach. Awesome job, Sarah. Can the employer pay the base wage below the minimum wage if commissions are added to make the minimum wage? Gussie, I don't know, actually. And that's a great question. I think ACAS will know, and ACAS are very good at pay things like that. So I would phone them and ask. Let's see. Okay, I'm going to go soon. Let me just check the time. Let me see how I'm doing. Okay, yeah, I'm going to go in just a minute. So I'll answer a few more questions before I go. Oh God, I've lost the tab. I've lost the tab. This is a disaster. Okay, I've got you back. How successful are whistleblowing cases? If you go to the Employment Tribunal statistics from the Office of National Statistics, they will show success rates. It's a little confusing though, because they basically show if a case has been withdrawn, and they don't say if it's been withdrawn because somebody decided to stop or because they settled. And then, but beyond the withdrawn, they will show if it went to final hearing, if it was successful or not. And so you will be able to see that by the different types of claim. So yeah, depends on how you're doing it. Can a judge order a stay on a case management if you object, but the respondents agree? So the judge can basically do whatever they want, Ms. Diva, unfortunately. So I don't know what a stay is in this particular situation, but a judge can basically, like you and the respondent can disagree about something, and that's what the judge is there to rule on. Even the pre-trial things like what's this deadline and things like that. So basically any question that starts with can the judge, generally the answer is yes. Let's see. Union rep CET. The union rep says the Employment Tribunal do not look at something that is part of an internal investigation. Is this true, please? No. My understanding is no. Internal documents are the bread and butter of evidence for Employment Tribunal. That is very, very, very commonly exactly what is relied on for evidence in a tribunal. I don't know what you would use otherwise. So, yeah, I'm not really sure, unless there's some kind of specific you can't use, like, if your employer is taking legal advice, that is protected, but beyond that I'm not sure what else is protected. I've never seen anything protected. Even medical records are something that is used as evidence. So yeah, I'm not really sure about that one. See Employment Tribunal help for explanation. Employment Tribunal help. Employment Tribunal help. Oh, my video. Actually, even better question. Armchair, can you email us hello@vala.uk, and we'll have a look at it there. Because rather than me kind of going around and trying to find a comment and then maybe you haven't had enough space to answer it. Okay, last few questions. Randall, my company put in an official letter that me putting down my nan's funeral as religious and my choice to do it was irrelevant, even though the event was religious. I had to go to temple. And this is that discriminatory? I don't know. I don't know. Short version. The location of a funeral being a religious place isn't probably relevant here. Typically, religious discrimination is relating to you wanting days of worship and your employer not giving them to you in that kind of situation. So I don't know about that one. Right. So, okay. So symbol, let me just answer. Let me just look at a few more. Can a judge order? Oh no, I've done that one. My nursing home carers who are on sponsorships are treated like slaves, and the manager is threatening that they will get them deported and can never get sponsors from other places. Oh my goodness. So I think that this is definitely one that needs some professional support, whether it's speaking to one of our coaches or speaking to a charity lawyer or a like a full fat law firm, something where people are immigrants might qualify for some pro bono work. I would go to a legal advice clinic at a university and ask them if they can support you on this. It's a really serious issue, and hopefully the fact that it's relating to people who are coming in on sponsorships and immigrating might mean that you get more support from a charity. So yeah, in general, if they are being treated differently because of their ethnicity, which includes nationality, then that could count as a direct discrimination on the protected characteristic of race brackets nationality. So yes, it does definitely sound like there's something worth exploring here. So yeah, I would encourage, because obviously it's not you, it's the people that you're talking about. I would encourage them to either speak to us, or if they can't afford to speak to us with the merits assessment, which is £150, then go to a legal advice clinic at a local university. There's usually legal advice clinics at all universities, and they're all starting back up now, which hopefully means that they would be able to get seen. Funny how you pop up on my FYP just as I lost my job of 14 years a few weeks ago. Oh, Motorhead, I'm so sorry to hear that. That sounds stressful. Yeah, we have tons of support on the website and on my videos. Let us know how we can help you. And I'm going to go, a Nigeria lady went through the same thing, and she took it to employment tribunal and she won. There you go. Yeah, I think there's definitely something there. And for everyone, Symbol and everyone, if I'm going to head off just now, but if you want to find out how much it costs or how we can help you, all that kind of stuff, email us, hello@vala.uk, and we will see if we can give you some support for all of these situations that all of you shouldn't have to be going through. Like, this is not okay. This is not okay that you're all having to go through all of this. I'm so sorry. But in the meantime, that's why we exist, and we're here to help as much as we possibly can. Well, thank you, Mez. Vala did my merits assessment. Highly recommend. That's very kind of you. Okay, right. I will leave you all this lovely Friday morning. And for those of you who have worked with us, please, the deepest favor I can ask you is to write us a little review on Trustpilot. It really does make a massive difference. And I'm so glad that we were able to help you. And yeah, have a great day, everybody. I will be online again soon, I'm sure, next week. And in the meantime, if you haven't already signed up for the newsletter on our website, that is where you will get the invitation to our Employment Tribunal support group. We're going to do a special one this month. It's going to be with some guest speakers, and it's going to be all about, it's a cognitive behavioral psychologist and a mediator who are experts in conflict resolution, and we're going to be giving you some tools and some frameworks for helping to figure out how to use your emotions during the tribunal process and the grievance processes, and hopefully not let them make everything harder. Okay, right. Mwah. Have a wonderful day, everybody, and I will see you soon. And remember, you can just email us if you have any more questions. Bye-bye. See you later, everybody.